The National Plan to End Domestic, Family and Sexual Violence makes a commitment to do that in a generation. If we want to achieve that ambition, we have to start with children and young people. But what we know is that even as children and young people are experiencing violence directly, they're often not thought about it in that way, from service responses through to policy drivers. We often think about them as witnesses to adult violence, and so we're not centring our services, our policy, and even our community understanding in that direct experience. What we're hearing at this conference is that children and young people know what they need. They know what it looks like for the services to respond, to help them to recover, and to be part of the prevention. But we have to listen to their voices, and we have to centre that experience in the work ahead. We often get asked what works, and that's a really simple question, and it behaves as though there's a really simple answer. What's been so clear from the young people and children that we've heard across this conference program is that they understand that what works for people in one community might be very different in another. What works in terms of being culturally responsive to the needs of Aboriginal and Torres Strait Islander communities or culturally and linguistically diverse communities might be different. They understand that, and still they can see paths forward if we take that understanding and we act on it. So I think that's a really critical call that we've heard from children and young people right across the program. Another really important insight that we're hearing from children and young people is that service responses currently are fragmented. And that means that even if children and young people get a response to their experience of domestic, family or sexual violence, that response might not connect with their mental health needs or their housing and homelessness experience or their need to maintain their education to secure their pathways to employment and income as they age. So they talk about a fragmented system, and we need to do better to connect up those service responses in response to that insight. As Australia's national research organisation for women's safety, it's ANROWS' role to develop the evidence to drive the change that the National Plan to End Violence Against Women and Children calls for. We've seen a phenomenal growth in evidence right across the country over the past 10 years and more. What we see as the really important direction ahead is helping people use that evidence. And the knowledge about children and young people is a good example. We've brought that evidence together in a set of insights that help us understand the directions being called for. The next stage is to make sure that evidence is actionable, that it provides really clear directions for policymakers, for service design and for practitioners working in those services, and for community attitudes to be part of the change that we all need to play a role in.
My research examines the impacts of trauma on children and young people, which often push them into contact with legal systems and statutory systems. One of the challenges that we see through our research is that young people in particular remain invisible as victim survivors of violence, but then their visibility becomes skewed and they get pulled into the spotlight when their experiences of trauma start to present in particular ways. So my research focuses on what happens when children move from presentations of trauma that appear as troubled to appearing to adults as troubled, when the manifestations of their trauma start showing up in their experiences at school, their behaviours in the community, their intimate relationships or their peer relationships or their violence at home. And despite the fact that we know absolutely that the biggest contributor to the use of harm by young people in these circumstances is their own experiences of harm, our responses to that use of harm are blunt and often punitive, where in some states, including my own in Victoria, young people as young as 11 or 12 can have an intervention order imposed against them, including where they might have developmental delays or disabilities, but an order is made against them with which they cannot possibly hope to understand or follow. So what this means is when they break an order because they don't know how to follow it, criminal charges ensue. So we are pushing victim survivors, young victim survivors, into criminal justice systems purely because of our failure as a community to keep them safe. The Centre for Innovative Justice, or the CIJ, is an independent research and reform body which works with policy and practice, works with courts, with government departments, with community-based organisations to build an evidence base in areas which are notoriously evidence-free. Justice systems are renowned for taking knee-jerk responses, and we need to build the evidence and bring the evidence to make sure that we are being trauma-informed, particularly in response to young people, and working not just to identify the problems but work on implementing the solutions. The term trauma-informed is used increasingly pervasively across our community and service responses, but often we don't necessarily understand or talk about what we really mean. We throw around the term and just assume that we all mean the same thing. What it should mean, or the phrase that I actually use, is trauma-based. And that is because children and young people, particularly who are coming into contact with systems, their entire experiences is dictated by their trauma. So that is the position from which we need to start and build from there, and letting that inform every decision or every consideration we have, how we work with them, how we show up, how we develop rapport, how we make sure that we don't betray their trust as adults, rather than bringing that into as a consideration at the end.
So my research aims to understand what participation means and why it's important to children and young people when their parents separate and are involved in the family law system. So I've been leading a project with colleagues at Southern Cross University where we are engaging in collaborative co-research with children and young people whose parents have separated and have been involved in family court litigation. And we've interviewed 41 children and young people about their experiences of participation in family law decisions after their parents have separated, and have also been working with them to co-create a children's participation toolkit, which is an online resource for children and young people to understand what their rights are to participate in family law decisions, and a who's who, so how they can get help, who they can speak with, and give them more information about the process. Now, there's a big gap and a big need for resources like this. The research that I've been doing with the young people has revealed that they've felt that they haven't been listened to or heard by family law professionals, and that they've been left in the dark. And that comment about being in the dark came up several times with the children and young people we've spoken with. I recall one young person, a 13-year-old boy, who said that the impacts of the family court proceedings were more traumatic for him than the impacts of his own parents' separation, because he didn't know what was going on. And so the message, or what they wanted to share, and what they had told the initial professional they spoke with, was not the same message that got to the decision maker in their case. Young people also shared that even if they did have an independent children's lawyer appointed to represent them, their best interests, many had never met their independent children's lawyer. And so they felt that it was incredulous that they didn't have the opportunity to meet and speak with the person who was there to represent their best interests. Now, some young people also felt that when they did meet with a professional, that it was very much a tick-the-box exercise. And some young people said, well, I felt like that the person I spoke with had a predetermined agenda, or there was a predetermined outcome, and they were just talking to me to tick those boxes because they had to. Now, young people also felt that because they hadn't been heard throughout this process, that in itself left them with trauma and guilt. And one young person, she felt that she felt responsible for the outcome, and the outcome was that she needed to spend time with a parent who she didn't experience as safe, because she felt that she hadn't communicated or articulated herself well enough to the professionals she spoke with. And she said, well, maybe if I'd said things differently, the outcome might have been different. And so we can see children feeling this sense of guilt, this sense of anxiety, because they don't know what is happening. And that leads me to a point that I think comes through strongly here in relation to children who have experienced domestic, family or sexual violence, that systems and courts, family courts in particular, cannot claim to be trauma-informed and domestic and family and sexual violence informed if they are not listening to children. That is an integral component. In this space, there is concern about needing to protect children, and that protection, the dominant approach is we protect children by not telling them anything and by not involving them and not asking them about their views, we're not giving them a say. And I think that we need to overcome that distinction between protection and participation, which has permeated family law. And the way forward here is to protect children in participation. So children and young people have said that they would like the opportunity to speak to the judge if that's available, or they would like the judge to write them a letter or to communicate the decision to them in some way, because it would provide them with a face or a person that they can associate with a decision that's a significant decision that's being made about their lives.
As Australia's national research organisation for women's safety, it's our role to develop the evidence base to drive the change that's called for in the National Plan to End Violence Against Women and Children. And over the past decade and more, we've seen a massive growth in the evidence. We've played a role, but many others have been contributing to that work. We've brought that together in a set of insights that draw on ANROWS and many other research base. And the evidence is really clear. The directions being pointed to are really clear. The work now is to make that evidence actionable. We need to work with policymakers, with the people designing and delivering services, and with the broad community whose attitudes are part of the environment in which gender-based violence occurs, so that evidence-informed approach is right across the system as part of the work to end domestic, family and sexual violence.